arrested person under BNS and under Indian Constitution. So the Bharatiya Nyaya Sanhita 2023 and the Bharatiya Nagrik Suraksha Sanhita define various offences and the procedure for their conviction. This act do not mention the right of arrested person in any particular section. It should be interpreted through various sections. The Indian Constitution grants us various fundamental rights. The arrested person also are the citizens of India and they are also avail certain fundamental rights. Now we will look into what are the rights. First is the right of the arrested person are as follows. Right to remain silent. So the arrested person has the right to remain silent during interrogation. He cannot be compelled to say anything in favor of him or against him. According to Article 20 subclause through, no man accused of an offence shall be compelled to be witness against himself. Please underline. So the doctrine of self-incrimination comes into picture. The accused is presumed to be innocent. It is for the prosecution to establish his guilt. The right that one cannot detain someone for more than 24 hours without any judicial scrutiny. As per section 58 of Bharatiya Nagrik Suraksha Sanhita, any person who has been arrested without a warrant shall not be detained. Please underline. Shall not be detained in police custody for more than 24 hours, excluding the time necessary for journey from the place of arrest to the magistrate's court. Okay, unless a special order has been made under 167. Next is right to know the ground of his arrest. So the right to get information is a fundamental right. So the police officer should inform the arrested person about the grounds of its detainment. Please underline the word grounds of its detainment. So any person who has been arrested without a warrant should have full detail for what act he has been arrested, for what crime he has been arrested. Okay. Then right to get bail. Please underline. So there are many categories of offences. One of them is bailable and second is non-bailable. The arrested person has the right to get bail in bailable offences. Moreover, as per section 48 of bnss, so if any person is arrested without a warrant in bailable offences, the police officer has a duty to tell to the arrested person that he is entitled for bail and he will be released on bail if he arrange sureties on this behalf. Please underline sureties on the behalf. Then right to get speedy and fair trial. So Article 21 of the Constitution guarantees the right to personal liberty, which includes right to speedy and fair trial. The state should not keep an arrested person in jail for unnecessarily period of time. Okay. Now right to consult a legal practitioner. So as per section 340 of BNSS, any person accused of an offence before a criminal court has the right to be defended by a pleader of his choice. Moreover, as per Article 22 subclause 1 of the Indian Constitution, an arrested person has the right to know the grounds of his arrest and he shall not be denied to right to consult and to be defended by a legal practitioner of his own choice. Now, right to be examined by the medical practitioner. Please underline, this is one of the very important segment. Once you are arrested, you will be first taken to the medical officer. Okay, your medical conditions will be first examined, then only you will be taken to jail. So being healthy is not a right. In the Constitution, but a requirement to encourage the livelihood of human. Moreover, section 53 of BNSS says that when a person is arrested, underline, he shall be examined by a medical officer in the service of central or the state government, and in case the medical officer is not available, then by a registered medical practitioner soon after the arrest is made. So once the arrest is made, first duty of the officer is to do your medical examination, whether you are fit or not, because after taking to the jail, if something happens, then who will be responsible? Okay, so because of that, they first investigate into the matter. Now, right to inform the relatives or the friend. So whenever any difficulty strikes down, families and friends are the person to whom you wish to contact. They are the people for the blessings in disguise. Similarly, an arrested person may inform his relatives and friend about the fact, time and place of arrest. So if the arrest is invalid on the account of breach of procedure or violation of any right, or the custody is passed within the framework of law, by a competent magistrate who has the jurisdiction over the issue, the person so detained can file a writ of habeas corpus. Please underline. Under Article 32 or 226, 32 is for Supreme Court and 226 is for High Court. Please make a note somewhere. It must be noted that the writ does not lie against legal custody, no matter what rights may be violated before lawful custody.